Your Honor, opposing counsel mentions that the arbitral clause is ambiguous. The arbitral clause meets all the elements of arbitration under the Federal Arbitration Act. It contains an agreement to arbitrate, defines the scope of arbitration, explains who will arbitrate, and the arbitration is final and binding. Opposing counsel states that the plaintiff is seeking both monetary and emotional distress damages. The damages come in the form of money specifically laid out in the clause. The clause holds that money damages related to employment are the issues to be decided in arbitration. Therefore, it is in fact within the scope of the agreement. Further looking at the arbitral clause itself, opposing counsel argues that their claims for a violation under the Whistleblower Act, wrongful termination, and assault do not fall within the scope of the arbitral clause. The claims brought in this case were made in order to get money damages. The arbitral clause specifically states that money damages relating to employment will be arbitrated. Although the claims the plaintiff laid out are not specifically stated in the arbitral clause, the damages that the plaintiff is seeking as a result of those claims are in fact within the arbitral clause. Under AMF versus Brunswick, the court concluded that the parties had agreed to arbitrate because at least one controversy, the factual issue of whether the advertising claim was supported, would be settled. Looking at this case specifically, the arbitral clause would settle the dispute. The arbitral clause would resolve the dispute for the plaintiff's claims by awarding the appropriate party with money damages. Therefore, the discussion of any money damages for the plaintiff are to be arbitrated. In addition, Your Honor, opposing counsel argues that the plaintiff never waived his right to seek legal recourse in this matter. Contrary to this statement, the plaintiff had adequate time to review the contract. The plaintiff did not argue that the arbitral clause was confusing, ambiguous, or vague at the time that he signed the contract. And within the contract, at the bottom, it states, "I hereby acknowledge receipt of this agreement with sufficient time to read it and consider each and every one of the provisions included in the dispute, including the dispute resolution provision." At this point in time, the plaintiff waived his legal recourse on employment issues that dealt with monetary damages. He's still, pursuant to the agreement, able to retain legal counsel in the arbitration itself, but the issues must be decided by an arbitrator upon signing this employment contract. Finally, I would like to stress that the plaintiff had a fair opportunity to read this contract and negotiate concerns with said manufacturing company. The plaintiff was in a clear mind when he signed the contract, which included the arbitral clause. The scope of the arbitral clause was clearly defined and is valid to compel arbitration. Finally, any and all preconditions were met in this case, and no exceptions written within the arbitral clause are justified here. Under first options of Chicago Inc. versus Kaplan, unless the parties have a clear and unmistakable evidence that they agreed to have an arbitrator decide arbitrability, the court is to decide. The court has the power to find the arbitration clause valid and compel the arbitration. Because the arbitral clause does meet all of the elements of arbitration and the disputes between the parties are arbitrable, it follows that the court compel arbitration. Therefore, we respectfully request the court compel the arbitration in this matter. Thank you.